Good afternoon, everyone. My name is Damila Kolawole. You're welcome to another Facebook Live session with Law Accent. Last week, we looked at managing employment disputes, but from the employer's perspective. For this week, we're looking at managing employment disputes, but from the employee's perspective. Now, you should understand that employment relationships are like other human relationships. There are bound to be disagreements here and there. And these disagreements could be as a result of personal differences, difference in personalities, because you're bringing different types of individuals together, individuals with different backgrounds, different work ethics together to work for a business purpose. So it means that there's definitely bound to be disputes among these people that are bringing together to work. So you should understand that even as you're taking up an employment, it might seem like it's a very good offer, your employer is a good person or it's a good organization. You should not rule out the fact that at some point you might have a dispute or two to settle with your employer. So it means that you should even take dispute management into consideration from the very beginning. That before you say yes to the offer of employment, what would dispute resolution look like with this employer? Now, I'll just briefly look at some things you should consider as regards dispute resolution before saying yes to the offer of employment. Then afterwards, we'll now look at after you've taken up the employment, if peradventure some sort of dispute arises between you and your employer. Now, before you take up that offer of employment, there's some things you should consider regards dispute resolution. Now, the first thing would be that what kind of organizational dispute resolution mechanism or culture is in place in that organization. There are some organizations that just run like that there is really no kind of structure put in place. There is really no form of human resource management that has been put in place in the organization. And you know that resolving disputes between yourself and your employer in such a situation might be quite difficult because there's really no internal form of dispute resolution in place. So you also look at that. For example, it's somewhere for you to start from, somewhere important to start from. Another thing would then be dispute resolution clauses and terms. Now, usually these terms, clauses for dispute resolution are usually imputed in maybe your employment contract. That is, if you have an employment contract, what the dispute resolution clause looks like. Now, most times, dispute resolution is usually not some sort of litigation. Most times, employers try to deter employees from litigation because they know that if something happens between them and employees cannot settle, and they are unable to settle the dispute internally, employees may have to resort to getting legal help from the outside. Employees may have to resort to litigation, and usually the implication of litigation for employers could be that they have to pay some sort of heavy fine, pay damages. It even usually takes a toll on the brand of the organization most times. So most times, employees just try to protect their interests by putting in dispute resolution clauses that limit dispute resolution to arbitration and mediation. So most times they just look at alternative dispute resolution methods. You could say from negotiation we go to mediation, from mediation we go to arbitration, and they just say this is how this dispute should be resolved. Now, even though it seems like it is put in place to deter employees from resorting to litigation, like I said earlier, it is not also totally at the detriment of the employees. So even though to an extent there is already a clause that binds you to alternative dispute resolution, does not mean that it also works totally against you as an employee. Those are the basic things I think you should look at out for as an employee before saying yes to offer of employment. So beyond how much you're going to be paid, beyond what their terms for promotions and other benefits that come with that employment, we also want to look at what dispute resolution looks like. So whenever any problem arises, it will be easier for you to settle it, to sort it out, because you already know what kind of steps you can take as regards resolving disputes. So, like every other agreement, every other contract, you should definitely peruse your employment contract if you have one, and maybe even seek legal advice where applicable, where possible, for your employment contract. So before you say yes to that employment, what is dispute resolution going to look like with your employer? Now, we'll now look at after you said yes to the employment. After you said yes to the employment, something comes up between you and your employer. What happens? What are the steps you can take? Now remember I said that if you have an employment contract and there are clauses and there's a clause for dispute resolution, like a clause that says you can only look at alternative dispute resolution methods. It means that you will not be able to litigate on that matter. Even though there is really no law that says you cannot litigate on employment matters, if it is a valid dispute resolution clause in the contract that binds you to alternative dispute resolution methods, then you have to go through that method. You have to resolve your disputes that way. But would advise that you do not start out by taking external help. If you have issues with your employer, try starting out with internal dispute resolution mechanisms. That is, remember I mentioned earlier that before you say yes to that offer of employment, you should try to make sure that it is a place where there is an internal structure for this dispute resolution in place. So if you have grievances against your employer, if you think it could be maybe promotion, you think you deserve a raise, deserve a promotion, you believe that maybe your employer's work ethics are something you cannot cope with. If you have any issue or the other with your employer, you might I think it's advisable that you start with internal dispute resolution. So if you have the HR department or you have supervisors, you can start by taking steps with that. And if this does not work out, you can then resort to looking at the outside, basically external steps. Now, after you've tried settling that dispute internally and it does not work out, the next thing you would have to do is look at your contract of employment, your employees handbook, and other applicable agreements. What you'll be doing by looking at these things is that you'll be guiding yourself by the terms of employment with your employer. You look at this agreement, what terms are provided for dispute resolution, how are disputes to be resolved according to this agreement that I have with my employer, because you are bound by the agreement that you've signed with your employer. The terms of employment are what would dictate how your dispute should be resolved. So if you look at it then, and when you look at it, it is what is contained there, where the terms of employment provide that you can seek redress in any way possible, you can go to court, you can do anything you want to do. Then you can begin by seeking legal advice on how to go about resolving the disputes. If you want to take action in court and against your employer, fine. But where it says that you have to seek alternative resolution methods, then you have to start by that, because you are bound by the terms of employment, like I mentioned earlier. Now, where applicable, that can go for litigation, you can start a court action against your employer. Even beyond court action against your employer, the rights that are generally available to you as an employee, that's from your employer. It won't be that you could be reinstated into your position. That is where there is wrongful termination, where your employment is unlawfully terminated. Even though this remedy itself is still subject to mutual consent by the employer and the employee. So, if, for example, as a result of one dispute you have with your employer that you're unable to resolve internally, your employer sacks you unlawfully. And unlawfully would mean that the way your employment was terminated is against the terms of your employment, against maybe the agreement that the rules that govern your employment with that particular employer. So it means that termination was lawful. So in terms of unlawful termination, in situations like that, you can have a remedy like reinstatement to your former position. But like I said, it should be subject to mutual consent by both the employer and the employee, because there's a thing in law that cannot force an employee on an unwilling employer. No. So it's really subject to mutual consent by both parties. Another would be you could get damages, compensation from your employer, usually monetary compensation for the wrongful termination or for whatever wrong that's been done to you by that employer. You could get monetary compensation, and it could also, there's also something called terminal payment. You could also be paid. The remedy could be that you would have to be paid some things that you would normally be required to be paid, if as if the employment itself was still subsistent. Maybe maybe if you have maternity leave, you still be paid leave, and maybe some other benefits I normally have access to under the employment. That is if the employment itself was to sustain that terminal payment. So usually these are some remedies that you may have as an employee remedies that you may have access to as an employee where you have issues with your employer. But remember, like I said, it is easier for you, it is advisable that from the very beginning, before saying yes to that employment, you carefully peruse what this resolution would look like. There are some terms of for dispute resolution that, even though they say that it should be purely alternative dispute resolution methods, there are some terms that still allow that you can still seek court directives for matters that are very urgent, for urgent matters. There are some clauses that allow for that. But really, most times employers just look at the ADR method because they don't really want to have they don't really want to have issues with their employees in the public, because like I said, it brings down the brand of the company, and then most times when they go to court, they have to pay lots and lots in damages, cost for lawsuit, and all of that. So it's better for you to, from the very beginning, before saying yes to the employment, to carefully look at what the terms of employment would be, and where a dispute comes up at some point with your employer, try to seek internal dispute resolution methods, try to go through internal dispute resolution methods, try to report to supervisors where you have, try to go to whatever department is in charge of resolving disputes where you have one, and if it does not work out, then you can now go back to your terms of employment. And I also like to advise that as an employee, don't just jump straight to court against your employer. Do not forget that you have agreements that guide the term of employment. So you need to look at what terms of employment are, and it is usually advisable that you seek legal help. If you have issues with your employer, your employment was wrongfully terminated, consult with your lawyer, ask questions so you know what the right step to take would be. And don't forget that even while you have issues with your employer, you should also bear in mind that you have other prospective employers. So beyond whatever the problem you have with that particular employer is, remember that you might also want to work in that sector. So you might want to be careful with how you go about handling the situation, so that it does not, at the end of the day, affect your personal professional career. Because we've seen issues where people have big problems with their employers, and as a result, even when it is eventually made a public thing, that where they're eventually compensated in one way or the other, it comes back to affect their professional careers. So whatever method you decide to take as regards resolving disputes with your employers, bear in mind that you also need to take into consideration how it would affect your personal professional career. So I hope that you've been able to learn one or two things from our session today as regards managing employment disputes as an employee. Remember, I said, as a prospective employee, before you say yes to that employment, look at the terms of employment. What would dispute resolution look like? Where disputes eventually come up, remember I said, try to sort them out internally before you seek external help. Try to always sort them out internally before you seek external help. And if you have a situation where you eventually have to seek external help, go back to the agreements that guide your terms, agreements that guide your employment relationship, led by the content of this agreement. Thank you for being a part of our Facebook Live session.